So it's a general principle of litigation that the conclusions being sought in a motion should be clear, concise, well-drafted, enforceable, and ideally constitutional. Viva Frei, I suspect you all know who I am, but in case you don't, I'm a Montreal litigator turned YouTuber. Ever since my channel started focusing on these things called vlogs, VLAWGS, where we break down and analyze something that's going on in the legal world in terms that can be understood by lawyers and non-lawyers, like blah blah blah, a lot of you have been asking me to cover the subject of Phil Demers being sued by Marineland. Now, I am almost embarrassed to admit that as a lawyer and as a Canadian, I was not even aware of the Marineland lawsuit against Phil Demers, so I started looking into it. I watched Phil Demers' podcast on Joe Rogan. It's fascinating, and this is going to be a multi-episode series. And incidentally, if you're watching this before August 18th, I'm going to be doing a live stream with Phil Demers on my channel August 18th, 1300, 1 o'clock Montreal time. Tune in, it's going to be amazing. Before then, I said I was going to tackle and dissect the amended statement of claim, which is basically Marineland's lawsuit against Phil Demers. It's very easy for anyone to criticize the work of others. My father always said that those who don't do, criticize. And yes, there is some truth to that, in that the people who actually do things are going to do things that are susceptible of criticism. Those who never do anything can sit back and criticize others because they never do anything themselves that is itself susceptible of critique. That said, I read Marineland's lawsuit. I would not have drafted it this way. But before we get into that, for those of you who might also be unfamiliar with the Marineland Phil Demers lawsuit saga that's been dragging on for over 6 years now. Phil Demers was hired by Marineland, I want to say sometime around 2007, to care, treat for, train some of the animals. Something unique happened while Phil Demers was working for Marineland, in that a walrus named Smooshi apparently imprinted on Phil Demers, and subsequent to the imprinting basically regarded Phil Demers as his mother. Her mother? Her mother. Smooshi's a girl. Basically, Phil Demers became Smooshi's mother, Smooshi followed Phil around, and they had this unique relationship that took everyone by surprise. And apparently this relationship arose in part because of the fact that Smooshi's mother was apparently murdered when Smooshi was taken into captivity and brought to Marineland to be one of their exhibit display animals. So Phil Demers and Smooshi developed this unique relationship that attracted the likes of media. It became the subject of articles, etc., etc. Phil Demers even ended up on a show called Wipeout Canada that he actually won, and he walked away with the $50,000 prize for winning Wipeout Canada. Sometime around late 2011, early 2012, Phil Demers submitted his resignation to Marineland. The versions as to why Phil Demers submitted his resignation from Marineland will vary depending on who you ask. Phil Demers says that he resigned because he became aware of and very concerned and distraught by what he felt to be the mistreatment of the animals being held in captivity at Marineland. According to Marineland, and as we're going to see in their amended statement of claim, they think that Phil Demers quit because he was upset that Marineland wouldn't let him become some sort of star with Smooshi and sign on to certain reality television shows, etc., etc. Rashomon. Subsequent to his resignation, Phil Demers has become an outspoken animal rights activist and critic of Marineland. Incidentally, it's worth mentioning that Phil Demers and Smooshi, who had imprinted on Phil Demers, haven't seen each other in upwards of 5 years now. But that is the 30,000-foot overview of the overall contextual landscape explaining this situation. Subsequent to his resignation and becoming an outspoken animal rights activist and critic of Marineland, Marineland filed a lawsuit for upwards of $1 million against Phil Demers, and that is what we're going to break down right now in episode 1 of the Marineland Demers saga. Ontario Court of Justice, Marineland of Canada, Inc., plaintiff, and Philip Demers, defendant. Amended statement of claim. It's worth noting that everything that is amended in amended proceedings is underlined, and the reason for this is actually very practical and very useful. When you amend a proceedings, because you can do it as many times as you want, pretty much, you want to know what the amendments were, and the easiest way to identify what the amended versions are or what the amended sections are to any statement of claim, lawsuit, motion to institute proceedings, whatever the terminology is in your jurisdiction, the easiest way to identify that which is new, amended, added, is having it underlined. And if you have a re-amended statement of claim or a re-amended whatever, only the new sections that are introduced through amendment are underlined, and that which was underlined becomes no longer underlined, such that you can identify what the newest additional amendments are to any amended lawsuit. And if we skip to the end of the lawsuit, we can see when this was amended. It was amended in October 2018. The initial lawsuit was filed in February 2013. If anyone wanted incontrovertible evidence as to how long, tedious, drawn out, and painful the litigation process is, this is pretty much your stellar example. So to open up their lawsuit, they start with the nature of their claim and they set out the conclusions that they're going to be seeking. And these are particularly mind-blowing from a legal perspective, so let's just read through them and then I will give you my commentary. The plaintiff, Marineland of Canada, Inc. Marineland claims against the defendant, Philip Demers, an interim, interlocutory, and permanent injunction restraining the defendant, Philip Demers, and any and all persons having knowledge of this order from directly or indirectly by any means whatsoever. And let's just pause right there to explain what an interim, interlocutory, and permanent injunction is. An injunction is an order of the court court enjoining, forcing, compelling someone to do or to not do something. Interim injunctions are short time frame injunctions, sort of like urgent injunctions to stop someone from doing something on an immediate basis, pending a hearing on the interlocutory injunction. The interlocutory injunction is sort of like a midterm injunction that you have until you can have a trial on the merits. Because as you can see in this particular case, which has not yet gone to trial after 6+ years, the interim injunction gets you to the interlocutory hearing. You have a hearing on the interlocutory injunction, the order of which, in theory, should remain in effect until the hearing on the merits on the permanent injunction. And depending on the outcome of the permanent injunction, you can have your permanent injunction be granted in whole or in part, and that permanent injunction remains in effect permanently subsequent to the permanent injunction final judgment granting the permanent injunction. But let's go and dissect some of these orders that they're trying to get on an interim, interlocutory, and permanent injunction basis. Trespassing on Marineland's private property at whatever. To the extent that trespassing is a statutory or criminal offense depending on your jurisdiction, one typically does not need a civil judgment to compel someone to comply with the law. That is what we call redundant. One does not typically go to the civil courts to demand that the judges issue orders enjoining people to respect the law. It goes without saying. Demonstrating or in any way directing protests against any employee, agent, or independent contractor of Marineland. Now, at first glance, this one struck me as being potentially unconstitutional in that it seeks to prevent someone from the ability of demonstrating, which is freedom of expression guaranteed by our Charter of Human Rights. But if we read it properly, Marineland, in this particular conclusion, is not seeking an order that someone be prohibited from demonstrating against Marineland. They are only seeking an order prohibiting someone from demonstrating against any employee, agent, or independent contractor of Marineland. I'm not sure it's any better, but it is a nuance that one cannot overlook. But if we move on, we're going to see that this nuance is disregarded in subsequent conclusions being sought. Physically preventing, impeding, restricting, or any way physically interfering with or counseling others to impede, restrict, or in any way physically interfere with Marineland's carrying on of its business, including its operations at blank. We seem to be getting very close to Marineland seeking an order of the court basically prohibiting someone from protesting Marineland's activities, which seems like it might be unconstitutional. Let's move on. Demonstrating in any way directing protests at Mrs. Holler's personal residence or interfering with her privacy or intimidating her or her family, whether by identification of Mrs. Holler's personal residence or other means of identification, including without limitation identification of Mrs. Holler's motor vehicle or that of any member of her family. For those of you who are unaware, Mrs. Holler is the wife of Mr. Holler, who was the founder of Marineland, and as you can see from this particular paragraph, it is underlined, meaning this was a paragraph added in 2018 after Mr. Holler passed away, and we'll see these amendments reflected throughout the motion. Threatening or intimidating Marineland's employees, veterinary staff, servants, agents, customers, or other persons having business with Marineland. Threatening or intimidating. Conclusions have to be enforceable. A court order has to be sufficiently clear so that people know what they are complying with. Threatening or intimidating. These seem like very subjective terms that even if a court rendered an order saying that they cannot threaten or intimidate Marineland or its employees, what is not intimidation to some might be considered intimidation to others. What others might not consider to be intimidation, others might consider to be intimidation in order to, let's just say hypothetically, fabricate violating a court order for the purposes of, say going after someone for contempt. And what do I mean by this? If someone violates a court order, in theory they can be in contempt of that court order. In order for someone to be held in contempt, they have to be petitioned into contempt. Proceedings for contempt have to be brought, and it has to allege the basis of the alleged contempt. If a conclusion of a court order says that one cannot threaten or intimidate somebody else, and somebody else says, I consider myself intimidated because they said boycott Marineland, therefore I want to hold them in contempt, one can see how ambiguous or fluffy or unclear conclusions can potentially be abused in order to bring about potentially ill-founded motions for contempt against somebody. Just hypothetically, it's not like it's ever happened in real life before. It's happened. It happens all the time. Moving on. And this is my particular favorite conclusion. Coming within 200 meters of Marineland property as defined by the official survey, except while in the process of traveling past the property in a vehicle on a public road for reasons unrelated to Marineland. Can we appreciate that Marineland is petitioning civil courts not only for orders preventing someone from demonstrating, but now preventing someone from coming within 200 meters of a property? That reeks of a restraining order in the criminal sense, and it's not clear that the civil courts are the proper venue to request these types of conclusions, but whatever, there are attorneys in the file who have made their decisions, and they will live with them when this comes to a hearing on the merits, but that conclusion seems a little problematic to seek in the first place. Oh, sorry, when I said that other conclusion was my favorite, no, this particular conclusion is my favorite. Utilizing a bullhorn or other electronic sound device directed at guests, visitors, or employees or towards the Marineland property. Marineland is seeking an order enjoining Philip Demers from using a bullhorn directed at the Marineland property. I was never a constitutional lawyer of practice, but I have a feeling that this conclusion is problematic from a constitutional level and from a practical level. Utilizing a bullhorn or other electronic sound device directed at guests, visitors, or towards the Marineland property. How can this conclusion as drafted be enforced if it were ever to be granted by the court? Spoiler alert, I don't think it ever could be. Here's another great one. Displaying, posting, or otherwise using any sign that utilizes any defamatory or obscene language in relation to Marineland or the Holler family, or, without limiting the generality of the foregoing, any of the following or terms of like meaning or effect: abuse, torture, criminal, animal abuse, arrest. I had seen a few interviews that Phil Demers gave where he said that Marineland was attempting to silence him, and I didn't fully appreciate the degree to which that was accurate until reading this lawsuit. Imagine that Marineland is petitioning the courts to get a court order on an interim, interlocutory, and permanent injunctive basis, enjoining Philip Demers from using certain words to describe Marineland. Imagine that! And not just that, they want to prevent Philip Demers from using the word criminal to describe Marineland. Count how many times Marineland used the word illegal to describe the alleged activities of Philip Demers in their own proceedings. Alright, and the other conclusions, which are just equally mind-blowing: intentionally photographing or taking any image of any employee or guest of Marineland or the Marineland property. Intentionally contacting in any way, including physically or through the internet, any employee of Marineland without their express written consent, other than for the purposes of contacting an employee to seek their express written consent. And they seek damages which, at the time of the initial filing, they numbered at $1 million, which they have subsequently specified to $641,037. A rather specific amount to quantify their damages at, but whatever, that's going to be their burden to prove at trial. And they are also seeking punitive damages in the order of $500,000. Geez Louise, we haven't even gotten into the actual allegations of the lawsuit yet. In the opening paragraphs, they describe what Marineland is, was, how it was founded, etc., etc., a general context of how Marineland came to be what it is today. At paragraph 5, we see that the word is crossed out and the word was is underlined, meaning that Mr. Holler has since passed away, such that he is no longer is the founder of, but was the founder of Marineland. Paragraph 6 is a very interesting paragraph, and it reads as follows. Marineland has been the subject of minor legal secondary picketing and protest activity from time to time over its 50 years of operation. This allegation reeks of legalese in order to minimize the scope of the protests that have been leveled against Marineland throughout its history. Look at all the qualifications in that allegation. Marineland has been the subject of minor legal secondary picketing and protest activity from time to time over its 50 years of operation. In non-legalese lawyer talk attempted to minimize the situation, Marineland has been the object of protests. Period. Oh, I spat all over my computer. Period. Paragraph 8 reads as follows. Marineland does not, however, condone the recent escalation in illegal conduct directed, organized, and participated in by Mr. Demers, who, in furtherance of his unlawful purposes and objectives, has engaged in dangerous and other illegal conduct, thereby putting employees, guests, Niagara Falls police officers, and Marineland's animals at risk. Marineland has repeatedly requested Mr. Demers to refrain from his illegal conduct to no avail. Marineland has requested the assistance of the Niagara Falls police in relation to the illegal conduct complained of. Mr. Demers has refused to comply with the lawful requests of the police. And this is what we call a grotesquely, nauseatingly self-serving allegation. Oh, Marineland has tried its best to ask him to stop doing his illegal stuff, but he won't stop doing his illegal stuff, despite our requests, our polite, repeated, just reasonable requests to stop the illegalness. Oh, okay. At paragraphs 10 and following, Marineland goes into who Philip Demers is and how he came to be an employee at Marineland, bearing in mind this is their version of events. And what we notice in their description of their version of events is the narrative that they are attempting to portray. They are attempting to portray Phil Demers as some sort of glory hog, somebody who wants stardom, somebody who wants to exploit Smooshi and his relation with Smooshi for his own personal gain. And when Marineland righteously says, no, Mr. Demers, don't you see that you are power hungry with stardom? And when they say, no, we can't do that, it's not in Marineland's best interest, it's not in the animals' best interest, that's when Phil Demers goes off the deep end and has a personal vendetta against Marineland, which is all that this is about. That's the narrative. I've just saved you reading however many allegations there are to describe this, but you can go ahead and read it if you want. That is the narrative that Marineland is attempting to portray. Later on, Marineland alleges that Phil Demers filed complaints with animal rights groups who came and conducted an investigation, only to find that Marineland doesn't abuse their animals. But Mr. Demers cannot accept those conclusions. Paragraph 26. Mr. Demers rejects non-violent expression of opinion. Mr. Demers has engaged in confrontational and illegal conduct in furtherance of his unlawful stated goals in relation to Marineland, its employees and agents, and Mr. Holler, as hereinafter described. Mr. Demers rejects non-violent expressions of opinion. There's There's a concept in law, in psychology, in humankind called projection, and that is we accuse others of what is true of ourselves. And if one were cynical and jaded, one could think that it reeks of pure projection from Marineland to accuse Phil Demers of rejecting non-violent expression of opinion. If one were cynical and jaded, hypothetically. Because what is going on here ultimately is that we see Marineland suing Phil Demers for what many believe to be non-violent expressions of opinion by Phil Demers. And what is Marineland doing? Rejecting Phil Demers' non-violent expression of opinion by attempting to sue him into silence. Carrying on. Despite demands by Marineland that Demers cease and desist his unlawful conduct, Mr. Demers, together with other activists, trespassed onto Marineland property and into Marineland Stadium during a live marine mammal show on October 7, 2012. Mr. Demers placed activists in the stadium during the show and prior to the unlawful storming of the stadium. Calling something unlawful doesn't make it unlawful. One should allege fact and not law in illegal proceedings. Nobody cares that Marineland or its lawyers qualifies everything and anything they don't like as unlawful, illegal, etc., etc. Describe what happened. A judge is going to determine whether or not it was unlawful. Mr. Demers knew the show was being watched by numerous families, including many young children, some of whom were in strollers. If one were cynical and jaded, one could conclude that this is opportunism, exploiting the fragility of children in furtherance of your own personal agenda. Won't someone please think of the children whenever you hear that? Ask yourselves what the ulterior motives are for invoking the children in defense of your position. Always. If one, wants to get old, cynical, and jaded. Carrying on. To Mr. Demers' knowledge, numerous individuals engaged in the storming of Marineland deliberately concealed their identities by removing distinguishing t-shirts or donning masks prior to entering the Marineland property. What I love about the litigation process is how everyone magically and suddenly becomes telepathic. They know what other people are thinking. They know what they know. They knew it. They knew what Phil Demers knew. Mr. Demers knew that upon entering the stadium, activists, including the activists previously positioned in the stadium, intended to and did engage in deliberate, aggressive, intimidating, threatening, hostile, and very loud shouting in order to halt the marine mammal show and cause families, including young children, to flee the stadium. There's drama, and this is drama. Paragraph 35. Mr. Demers has otherwise engaged in illegal conduct and has posed a continuing risk to Marineland, its employees, agents, and animals, and to members of the public as follows. I can't read through all of these because there's just too much, but I want to skip to the last one because it is... Mr. Demers has engaged in illegal conduct and posed a risk for the following reason. Through social media, in respect of young children from the Beacon Christian School who attended at Marineland to sing Christmas carols, Mr. Demers published statements that it was shameful that they would do this and that they should expect a great deal of backlash for this. So now it qualifies as both illegal and posing a risk to go on social media and say that something is shameful and that someone who engages in a certain conduct should expect a great deal of backlash for this. Illegal? Some might consider that to be not just inflammatory rhetoric, but ultimately untenable and over-the-top rhetoric intended to suppress the freedom of expression and the freedom of protest. Some people. I'm not saying me, I'm saying some people. Moving on. Paragraph 37 and the subparagraphs being underlined are additions that were made in 2018, and they read as follows. From 2012 to date, Mr. Demers has repeatedly expressed his disdain for Marineland and Mr. Holler by posting numerous personal attacks. For example, I want people to appreciate this. This is in a lawsuit to justify damages saying that someone has expressed their disdain for Marineland and its founder. Let that sink in. But let's go see what Mr. Demers said that could justify a claim for $1 million in damages, punitive damages, interim, interlocutory, and permanent injunctive relief. In or around 2013, Mr. Demers created a Facebook group titled Occupy Marineland. On January 16, 2014, Mr. Demers posted to his Facebook a caricature-type picture he created of Mr. Holder holding a shotgun with a caption above claiming the following accusations. Marineland can owner threatens to stab activists at the Mike Garrett on camera. I don't know what they're talking about, but if someone said he was going to stab an activist on camera, yeah, are we saying that one cannot relay that information to the general public? On January 30th, 2014, Mr. Demers posted to his Facebook a caricature-type picture he created of Mr. Holler holding a shotgun with a caption above stating, perhaps it's the emergence of a new whistleblower or maybe it's senility. Either way, John Holler just did another of his familiar slow drive-bys. Couldn't get a snowball ready in time. Damn. Because apparently, according to Phil Demers, Mr. Holler was doing these random drive-by Mr. Demers' residence, according to Phil Demers, in an attempt to intimidate him. All that to say is these are the allegations being raised by Marineland to support a permanent injunction enjoining Phil Demers from protesting, coming within 200 meters of Marineland's property, or directing his voice via bullhorn to Marineland. Some people might consider this to be what is referred to as a strategic lawsuit against public participation, a slap suit, a lawsuit intended to silence someone from criticizing somebody else. Some people might consider this to be that. Some. In August of 2015, Mr. Demers posted to his Twitter account the following: "When this is all said and done, I think Marineland's lawyers should have to atone for their unethical abuse of the legal system." Whoa, Phil. Let me give you the lowdown here. If there is one thing that lawyers hate more than being wrong, it is being publicly mocked by the person they are suing. Now you know. Alright, we can do this all day, but you get the gist of it. Marineland is basically suing Phil Demers for protesting Marineland. They're making all sorts of accusations of illegal conduct, of violent conduct, etc., etc. That will be their burden to prove, but they are effectively going after Phil Demers because he decided to protest and become a vocal activist against Marineland after he left because of their treatment of the animals, and probably, in part, because of the way they're treating Smooshi, with whom he has a very unique relationship, whom he hasn't been allowed to see in the last 5 years, etc., etc. But let's read paragraph 38 because I love the way this paragraph is drafted. On or about May 16th, 2018, prior to opening day at Marineland on May 19th, 2018, Mr. Demers obtained tickets to Marineland for purposes other than the purposes under which the tickets were issued. This is so that demonstrators be controlled and directed to enter the park and disrupt operations. Phil Demers bought a ticket for purposes other than the purposes for which tickets are being sold. In other words, he bought a ticket so that he could protest Marineland, but Marineland doesn't sell tickets to protesters. Marineland's not going to sell tickets to anyone who is going to criticize them. It's on the terms and conditions of the tickets. Paragraph 41. During the course of the demonstrations, demonstrators controlled by Mr. Demers trespassed on Marineland's property. Look at this allegation. It is alleging that the demonstrators are controlled by Phil Demers. It is alleging that other autonomous human beings are controlled by Phil Demers, that he has such power that he controls other people and as such is responsible for their conduct if it happens to be illegal or whatever. The demonstrators controlled by Mr. Demers failed to abide by the lawful direction of the police. Paragraph 48. On September 3rd, 2018, following the Marineland demonstration, Mr. Demers posted on his Twitter account that evidently someone graffitied up some Marineland highway signs. My guess? Disgusted patron. Wasn't me. Why is Marineland publicizing this? Yes, Marineland. It's very possible, very probable that there are enough people out there who are disgusted with Marineland as a business that they would graffiti up your signs. Have you ever heard of the Streisand effect? By making these allegations and attempting to pin it on Phil Demers, all that you're doing is publicizing the fact that people don't like Marineland. There are other people out there, above and beyond Phil, who reasonably have issue with Marineland and its treatment of animals, of its holding in captivity highly evolved, highly intelligent, highly social animals. People take issue with this. You could try to blame it on Phil Demers, but by alleging this in a public proceeding, all you're doing is making even more public the fact that people hate Marineland. That's it. I can't do this anymore. You have a gist for the proceedings against Phil Demers instituted by Marineland. The ultimate travesty in this entire legal saga is the fact that the legal process drains people economically, spiritually, psychologically, emotionally. Imagine being sued 6.5 years ago and having yet to have your day in trial because of the nature of the litigation process. We're going to get into this, especially when I do the live stream with Phil Demers, to get into the details of what's been going on in this file. Because having a legal background and knowing the ins and outs of the Canadian legal system, I'm going to be able to ask Phil some of the questions that maybe Joe Rogan didn't know to ask because he's not a Canadian lawyer. Regardless, the process itself crushes, destroys, drains. Being sued for over $1 million and having accusations of illegal conduct included in public court proceedings, that itself takes a toll on somebody. And I've always said this as a lawyer, I never alleged illegal conduct in a proceeding. There's a difference between unlawful and illegal. Making public accusations of someone being a criminal, having committed crimes, having committed illegal activity is defamatory. Describe the facts. A judge is going to come to the conclusion whether or not it's illegal. But having such a lawsuit looming over your head for over 6 years, having such egregious, over-the-top accusations being leveled against you in public court proceedings, for anyone who doesn't know how emotionally draining and exhausting that is, all the better and more power to you. May you never know it. But it is. And for it to go on for over 6 years before having your day in court, some people can come to the conclusion that there is something fundamentally wrong with the legal process that would allow for such a situation to occur in the first place. Alright, next up, we are going to be analyzing Phil Demers' defense and cross-demand, or cross-statement of claim, because Phil Demers is countersuing Marineland for abuse of process and other related damages, as well he should, as well any lawyer representing someone in Phil's shoes should do for them. The judicial process is not a pawn in a game of chess. It is to be used when it is justified to be used. When it is unjustified and when it is being abused in order to silence someone or sanction them, that is exactly when counterclaims for abuse of the legal process should be instituted. Alright, I am super psyched for the live stream with Phil Demers. Demers. It's going to be mind-blowing and eye-opening for anyone who is not already familiar with the legal process. Be sure to tune in August 18th, 1 o'clock, 1300 hours, Montreal time. In the meantime, if you like my content, you like my channel, be sure to like, share, subscribe, hit the notification bell, leave a comment in the comment section. I have been told now that my channel is getting throttled. I have had many subscribers tell me that they have been unsubscribed unbeknownst to them, or that they have had notifications turned off despite having turned notifications on. So there may be some tomfoolery or some chicanery occurring within YouTube, or maybe it's all just a coincidental accident, whatever. Help me grow my channel, help me succeed on this platform, get the word out there, and now you know your vlog. Peace out. Boom!